If you're applying for disability benefits or help people that are, the path to success has never been more complicated. Welcome to the Disability Expert Podcast, where we tackle the difficult issues and interview the country's top experts to help you better navigate the disability process. Winning a disability case is hard and keeps getting tougher every day. We can't promise you'll win your case by listening, but we sure think it's going to help.
This really isn't that complicated. I mean, you want to win your case, don't you? Well, then listen to what I say.
Hey, welcome to Disability Expert Podcast. I am Chad Brown. I'm your host, and I'm excited today to have continued conversation with Jonathan Ginsberg. If you want to, this is part two of a two-part episode. If you want to see part one, you cannot find it on my YouTube page. You have to go to Jonathan's YouTube page. Address is in the show notes, and had a great conversation in episode one. We talked about his YouTube page, his contribution to the information economy for disability claimants, 11 years producing high quality content. And we talked about age as a vocational factor. We talked about judge bias and working on those cases, and just so thankful that you're on the show. Continue the conversation. We talked about sort of big picture things, age, ALJ. I think those are two sort of factors are really beyond your control that have a huge impact, but there are a lot of things within your control. So what I really hope to do, if we could go through in our episode today, is go through and look at some very practical things. Obviously, you're a day-to-day, some people probably may think you're just a YouTube personality. Like, you're actually a day-to-day practitioner, expert disability lawyer, do literally hundreds and hundreds of hearings every year, done thousands of hearings in your life. And so I want to just give people the opportunity to hear that insight. The hearing for a disability claimant is very often the most important day of their life to that date. I don't want to trivialize marriage and birth of children, but when you're unable to work, you have no hope for income, you can't get the medical treatments you need. This day is super important, and I think it's important that people understand there are right and wrong ways to do hearings. Yep. There are good ways to testify and bad ways to testify. There are routes that get you to a favorable decision, like we talked about before, and there are routes that end up with an unfavorable decision and a lot of pain and anxiety. So let's get into talking about hearings. One of the things that I think is important is, if you start at this, let's just start at the beginning of a hearing. There's a lot of these mundane questions. They seem to be throwaway questions, but yet people often struggle with them. They're not prepared for them. Talk about, so what's the introduction component of a hearing like for the client? What types of things are they testifying? What are some things they need to know to make sure they don't sort of miss the softball they're getting tossed there at the beginning of the hearing?
Yeah, I mean, I think that's a very good point, that most hearings, there's a certain percentage of the questions that are the same. And you really should not be thinking about that for the first time at your hearing. So, for example, at the beginning of a hearing, and now most hearings are done by phone or video, so they're virtual, the judge is going to ask you, are you okay with a telephone hearing or a video hearing as opposed to a live hearing? Well, that's something you should have already decided. You shouldn't think about, well, do I really have, you want to be able to say, yes, I'm okay with the telephone hearing. By the way, they work really well. So I'm a big proponent of telephone hearings, even more so than video, because there's less to go wrong. But I think that's an example of something where you shouldn't have to think about it. The judge will ask you, are you prepared to take an oath? Again, not a big deal, but you shouldn't have to think about that. The judge will ask your attorney, have you reviewed all the records? Have you discussed the issues? Yes. Then the judge will ask you about your past work over the last 5 years. Again, not something you should have to think about. You should have it right in front of you. Who you work for, what you did. Not just your position, but what you actually did. That's something that is going to happen in every single case. Be prepared to give an elevator speech. Some judges will say, well, Mr. Jones, tell me in your own words why you think you're not able to work. You ought to have an answer for that. That's not something you should be thinking about for the first time at the hearing. This is something you should have a 3 or 4 sentences. You can write it down. You can have it in front of you there. You should know the medications you're taking and what side effects are going on. And again, when you practice with your attorney, does this make you drowsy? Does this will make you go to the bathroom a lot? Does this will make you loopy? Those are the sort of things you should have already prepared. You need to know, if it's a physical case, if there's physical issues, how long you can sit, stand, walk. And again, one of the mistakes to avoid, don't say not very long or not too much at all. Or what do you do during the day? I just piddle around. Well, that doesn't, you got to be real specific. Or it depends. Some days this, some days that. No, you have to pick an average day. I'd say an average to below average day, not the worst, not the best, maybe even the middle minus, and be able to talk about how long you can do these things. Can you kneel, crouch, crawl and stoop, those type of things. These are questions that are coming up in every single hearing. And there's no reason not to be able to answer those quickly and
Sure.
definitively. So that's the sort of thing. Those are the questions that are going to come up, in every single hearing. The other thing I would tell people, and I tell my clients is, if there's stuff in the record, you smoke marijuana, you've sometimes taken somebody else's medication, don't lie about it.
Yeah,
It's going to
for
be in the
sure.
record. If you rode a motorcycle one time, don't lie about it, because if you lie about something relatively trivial, that makes you seem not believable all throughout the whole hearing. So
Yeah.
again, these are just the sort of things that a good hearing preparation you'll go through, but you'll know. But again, don't hesitate to write stuff down, have it in front of you. You don't want to read a statement, but okay, I know I said I can sit for 10 minutes, stand for 10 minutes. How much can you lift? 5 pounds, 10 pounds, and really think about that, but have good answers to those questions.
Yeah, I mean, I think a lot of times too, we get back into this question of, well, who's your judge? Because it
Mhm.
matters, because some judges will say, well, they're nervous, but you start equivocating on your work history, or you start, you can't explain to them, like I used to talk about, if I can't explain why someone's disabled in 2 minutes, they probably aren't. Now, granted, I'm an expert at them thousands of disability hearings like you.
Mhm.
You could probably summarize every one of your clients' cases in, a couple of seconds, a couple of minutes. But if you can't do that as a client, there's a whole group of judges out there that are sort of looking for a reason to question your credibility, to
Yeah.
question your motives, and being able to just be clear on things that aren't they're not debatable. These aren't subjective questions. You had a job. These are the years you had the job. This is what you did in the job. You should know. Like
Yeah.
this, and so you get into this idea of, sometimes you're in the clients and they're like, well, I'm so afraid of saying something wrong, I don't say anything. It's like, well, you don't know your birth date?
Yeah.
I mean,
Right. Sure. Yeah.
that sounds
Yeah.
absurd, but you get clients. I mean,
Right.
traumatic brain injury aside, you get clients who sort of like, they don't want to give an answer on really basic stuff, and I think it really turns the judge off.
Yeah.
I
Yeah.
think a lot of that's preparation. Attorneys should be doing that, but at some level, you got to take ownership. It is your hearing, it is your day in court,
Correct.
and you really, I mean, barring some sort of mental health issue or brain injury that keeps you from giving this basic information, you should be ready. You should be ready to get it.
Yeah.
To give
Absolutely.
that to the judge.
Yeah, absolutely. And I think that, I try to do a pre-hearing brief on almost all my cases where I
Right.
really spell it out. I spell out the theory of disability, what I perceive to be the most important impairments. My client looks at that. That helps a lot, because it gives them
Sure.
an idea of the roadmap of where I'm at. And by the way, one of the things that I tell people, everything else being equal, try to limit your impairments to maybe 2, 3, maybe 4. If you
Yeah.
give a list of 15 impairments, it's going to be really hard to win, because it's too scattered. You want to really
Yeah.
focus on the 2 or 3 things that have the most work
Sure.
preclusive implications. But yeah, you have to know where you're headed, and you got to be willing to talk about it, and talk about it clearly. You also want to come across, and this is something I always encourage my clients, you want to have an attitude that you're a fighter. You
Right.
hate the idea of being disabled. You don't want to come with the attitude of, I'm entitled to something. You need to pay me. I've given up. Judges
Right.
hate that. They absolutely hate that. So you go with the idea, if I could go back to work tomorrow, I would do it. And if you have the right attitude, you're clear and precise about your limitations. You give answers to questions. Another thing you ask me is, what should you have, what are the mistakes you can avoid? Don't interrupt the judge. The judge starts talking, your mouth goes shut. My mouth goes shut.
Yeah.
Don't interrupt the judge. Don't anticipate his question or her question. Don't argue with the judge. Don't curse. It's amazing to me. People will go into hearings. These are, again, they're informal. They're administrative law judge hearings. They'll start cursing. There may be children in the background screaming. I remember I had a hearing one time. Person lived in a house near an airport, and every 3 minutes you hear the screaming, of an airplane going by. Just things like that. If you're on a phone, make sure you have a good connection. I mean, that
Yeah.
frustrates the heck out of judges when they can't
Sure.
hear you. If you're doing video, don't use a phone that you're, moving around with. Have it set on a stand, or use a laptop. Just practical things. You want to make the
Yeah, sure.
judge's life easy, right? That's what you're trying to do.
Let's talk a little bit more about that. Let's talk about this issue that you bring up about sort of the mindset of the client, which historically, I think you could, there's people all across the spectrum. Some people are just complete victim. Everything's woe is me. Granted, they've had a hard life. I think they fail to recognize that almost everyone who comes in front of an ALJ has had a hard life at some capacity. That's why they're there. And then on the other side is sort of the, I'm thinking about a recent case we had where I really think it hurt my client that they were so refusing to acknowledge they were disabled. It was almost like we had to pull teeth. But here's my question. So it's one thing to get into a hearing and say, well, woe is me. It's another thing to get into the hearing and say, I'm a fighter. I'm trying to, but ultimately that's just your opinion. What do you think people can testify to or attorneys can point to in the evidence that's able to take away sort of the subjectivity of that and be able to sort of judge my client is a fighter because of this, either lifestyle things they do or evidence? Can you talk about that a little bit? Because I think it's right to get the mindset and the presentation correct, but it can't just be, well, Judge, I met with this person for an hour and I really think they're a fighter. Well, I'm sure you do, Mr. Brown, because you're going to not get paid if we lose. How do you actually link that to, some objective evidence where, we can sort of put legs under the table, put some feet to our argument with this issue? Because I really do think it's important. It's important to a lot of judges too.
Sure. Well, I think the first thing I try to do is acknowledge to my clients, and I have this discussion with all of them, that I recognize the idea of labeling yourself as disabled is a really, really tough journey to make. It's a tough transition. You're going from working, supporting your family, making money, interacting with people, to now you are, quote, disabled. So I think just acknowledging that and letting your client know that you understand that's a really difficult place to be. It's a difficult label to have. So that's the first thing. And the second thing is when you have a client, and I find this typically with men who are, they've been athletes, they've been strong, they've done physical type of labor, is to say, look, you have to just give a realistic explanation of what you can and cannot do. We go over it over and over. How much can you lift? About 20 pounds. Really? 20 pounds and 20-pound sack of potatoes, or, a toddler who's, 12 or 13 months old, that's right. 20 pounds. That's a lot of weight. And so you have to sometimes get people thinking about what they really, really can do. So sure. Yeah, I think for folks who are, they're a fighter, but they're beyond that. They don't want to acknowledge that they've got some weaknesses now. You have to kind of get that mindset where it's not a reflection on their character to say, yes, I can't do these type of things anymore. I can't perform this. In my mind, I'm still 18 years old, strong as can be, but realistically, I'm 57. I've had 3 back surgeries and I can't do these things. So, it's just practice. It's just getting people in that mindset of being able to admit to a stranger that, they can't do what they used to be able to do, and acknowledging, at least from the get-go, that I realize this is really, really hard. But, disability will give you some dignity. It'll have some money coming in. It'll get you Medicare. I mean, there's a lot of real positives to it if you qualify. And, I also explain to my clients, and as we've talked about, it's really hard to win. So if you can convince a third-party skeptical judge, there's something really going on here, that this is really about survival. But yeah, I think you have to, it's really important for the claimant, the client, to have the right mindset going in. And you're correct, it's beyond just I'm a fighter, but I'm also realistic as to what's going on with me. And I'm able to talk about it somewhat dispassionately, that I have these limitations and I can do so credibly. I don't want to have them, Judge, but I got them. I mean, I never thought in a million years I'd be talking to some judge about that I can't lift 10 pounds when I'm, 6'3" and 220 pounds, but I can't. And so I think it's just about getting the right, frame of reference for the claimant. Again, pre-hearing, just the discussions you have with your clients to let them know it's okay to let their guard down a little bit. And I think if you can do that, then it really leads to a much better outcome.
Yeah, I think this leads to another topic, which is how do we link subjective testimony with objective evidence? And that's a range of issues. But before we do that, let me get a word from our sponsor, CBIG. And we get back, I want to talk about this. How do we link up the objective with the subjective to make a good case?
Hey there, this is Kevin Rosenquist from the Disability Expert Podcast. Every week, Chad and his guests discuss the disability process and how expert attorneys help their clients obtain the Social Security disability benefits they deserve. But obtaining disability benefits is only half the battle. After winning your disability case, Understanding Medicare should be your top priority, and that's where CBIG comes in. Disabled individuals must get their Medicare coverage right. Trying to understand Medicare can cause anxiety, uncertainty, and even fear. CBIG works with Medicare beneficiaries on disability around the country and is committed to helping those on disability navigate the complex Medicare process. Visit CBIGcares.com today to see how CBIG makes Medicare simplified. Mention this ad and receive a free gift when you schedule a 10-minute consultation.
Okay, we are back, and I am talking with Jonathan Ginsberg. We're talking about we're deep in the weeds now about what people do in disability hearings and how we can really help clients position their cases in such a way they can win. Before the break, we were talking about this idea that clients need to present themselves really as being a fighter, and there's sort of a range of issues people have there, from sort of attaching themselves to victimhood to being so reticent to say that I'm disabled that they don't even want to acknowledge that they have the problems. But the reality is that, judges aren't supposed to necessarily base cases on character. But one of the arguments I used to make, we used to call it the Willie Luffman argument. I won't get into what the Willie Luffman argument is. It's my wife's grandpa. But the point is that people who have certain character act in certain ways. And you can look at how people act and make determinations about things like their credibility. So, for example, if someone it really is a fighter, they don't want to be here, you can look at it and say, look, they asked to have their job modified. They took a job with less pay. They changed fields. They took a pay cut. They went out on short-term disability and then tried to come back and work. There are things you can do to point into the client's history to say, this tells us something about this person that does impact their credibility. And no, Your Honor, I'm not asking you to award them based on their character. What I'm saying is you can't ignore it when all of the evidence is pointing to someone who lives and acts a certain way. That's someone who should be believed. So my question, though, is this is not just an issue of character. Mm-hmm. This is not just an issue of framing yourself as a fighter. This is the whole case. Because when your client comes in and testifies and says, I hurt, or I can't do X, or I can't do Y, these are sort of often arbitrary statements. They're subjective. We have to be able to link those to objective evidence so the judge can look at it and say, I believe that. How do you do that for your clients? I mean, what does that look like in a real case? Because I think that's the crux of winning cases. It's not just.
I think you're right. I think part of that has to be, you have to be very honest with your clients. Somebody may say, my disabling condition is my left foot, but I know, and that that's probably not going to be enough. It needs to be something else. So you've got to be able to look at the evidence and say, what gives me the strongest argument? A perfect example, I have people that will come to me, they've been diagnosed with fibromyalgia, legitimate condition. I truly believe fibromyalgia does exist and it can be disabling, but it's really, really hard to win disability cases based on fibromyalgia. So if somebody comes to me and that's what they're focused on, I'm going to tell them, look, if there's irritable bowel, that's going to be a stronger argument. If there's a disc issue, that's going to be a stronger argument. So the role of the attorney is to look at the evidence and say, what is the evidence that's most compelling, and base my testimony around that. And that's part about educating your client that they don't really want to be talking about, kind of these idiopathic, pain conditions, as legitimate as they may be. As the attorney, that's going to be really, really hard to win. So I think that, part of this is to realistically look at the evidence and say, this is what the evidence is telling me. This is what I think is going to mean the most to the judge, despite what you may believe, because people sometimes will say, well, my doctor told me, that this, and they kind of buy into that. That may not be the disabling condition. So you have to look at, medication side effects may be the most disabling part of it. You have to really flesh that out. So I think it's just, using your skill as an attorney to be able to identify those things that are most significant, that are going to lead to a judge concluding there are vocational limitations, and having the client prepared to testify about that, and also to maybe back off some of the things that the client believes that may not be winning arguments in a disability case.
I think a related issue too, and I'd love to hear your thoughts on this, is there is this issue of specificity in testimony. Mm-hmm. And so, for example, someone says, well, I can't lift X, the judge often is asking themselves, even if they don't ask the question out loud, well, how do you know that? So how do you work with your clients to get, okay, you make these statements about what you can and can't do. What level of specificity do they need to be able to make that argument fly, or to establish that limitation such that the judge, when they're asking the vocational expert, you got a hypothetical individual, that can lift X, Y, and Z, there's actually a foundation for it. Can you talk about specificity and testimony and how that works with sort of, building strength in these sort of subjective statements clients make?
Yeah, I think that, you have to give your client landmark. So for example, a gallon of milk is 8 pounds. So,
Right.
Can you lift a gallon of milk? That will give you an idea of what they can do. Can you carry it? Could you lift it off the floor? Could you hold, a gallon of milk and 2 gallons of milk, one in each hand? That gives them some sort of an idea. As far as, a bag of potatoes may be 5 pounds or 10 pounds. So you try to give them some sort of an idea as to what that really means. Or before the hearing, say, what have you tried to lift, and
Right.
get a sense of what that is. Like I said, a 2-year-old, 18-month-old, something like that, that's going to be 25 pounds, maybe 30 pounds. That gives you some idea. They've tried to do it. These are things they want to do.
Sure.
If you have a grandchild, you want to be able to pick him or her up. You got a 2-year-old and you can't pick them up because, you can't lift 30 pounds. That's telling you something. But again, I typically use the gallon of milk. I'll use a 5-pound, bag of potatoes, 2-pound bag of sugar, things like that somebody can relate to, and, ask them, have you tried to do that? When you go to the grocery store, you give a good example about how to talk about different things. Do you have the person bag your groceries in multiple bags? So, do you need help getting them in? But, you don't want to be carrying a 20-pound bag of groceries in when you're saying you can't lift more than 10 pounds. Talk about what happens if you overdo it, things like that. So it's really kind of on a case-by-case basis, but trying to figure out what, in their life they have done that they cannot do anymore, maybe is a good way to put it, and try to put some specific things, whether it's pounds or distance or time to it. You're taking a walk, I can go to the mailbox. Well, how far is the mailbox? And have them, I just measured, I walked, it was 45 feet. And I became, I had to stop at 45 feet, rest against the mailbox before I could come back. And
Right.
that's really the only way to do that, or unless they have a functional capacity evaluation from a physical therapist that's actually done the measurements. But otherwise, they just have to give examples from their life. But yes, you're correct. More than just, I can't lift 10 pounds or 15 pounds. It's got to give.
Yeah. And I think obviously should go without saying that the attorney should be in the pre-hearing building this context and stressing the importance of it. But for someone who's doing their own hearing, or for someone who is thinking about their own testimony thoughtfully, people, who come to your YouTube page, who are they're just trying to figure out what to do. They need to understand, you need to always be asking this question, well, how do you know that? I can, because if you look at sort of postural, sit, stand, walk, push, pull, carry, lift, you say, well, I can only stand this much or sit this much. Well, how do you know that? Well, because when we go to church on Sunday, I can only stand through the first hymn, and the first hymn is 6 minutes, and then I have to sit down. Okay, well, that's real testimony. That's really, it's difficult to refute that if you're the judge too, because now we've got a real testimony. It's not there's no other testimony that says, well, I go to church with her and she doesn't. She stands for 12 minutes, not 6. It's not like that exists. So I think the clients need to be thinking through, well, it's one thing for you to say it. It's another thing for us to say how you know that in a way that can be conveyed to a judge.
I think that you make a very strong point. That's a really good way to approach it, is to, think about some real life examples of those things so you can talk intelligently about that. Because you're right. Simply saying I can't lift 10 pounds doesn't mean as much unless you are relating it to something, or I can't stand, you're relating it to your church going, it makes perfect sense. That's a very good, very, very good point.
Well, we are out of time. I can't believe we're out of time. I have like 9 other questions over here I want to talk to you about. I don't know, maybe we can do another show. But thank you so much for doing this 2-part episode. I mean, just great information. Obviously, you're in the trenches every day dealing with clients, and these are the things they need to know. For the last decade, you've been one of the only just sort of valuable, practical resource on the internet that people could go to and trust. And if you didn't see part one of this thing, please go to Jonathan's YouTube page, check it out, subscribe to his page. There's just a wealth of information there. Subscribe to my page. We're bringing on the best experts every week to give you the information you need to hopefully win your cases. And with that, it's a wrap. Jonathan, great seeing you again. Hope to see you soon. And tune in next time. We'll interview one of the nation's best disability expert attorneys.
Very good. Bye-bye.